Hello, everyone. Good evening and welcome back to LiveLaw Academy. I hope all of you are doing great. To help you with your judiciary exam preparation, I have picked a topic today which has been asked in one of the upcoming exams for which you may have applied for. This topic is not just all the other judiciaries because this is one that is so mentioned here. What is a definition of mediation and the judicial settlement and how by way of judicial intervention the judiciary has tried to interpret this provision in a manner which is complementary to ADR laws, which is complementary to the purpose and objective of recognizing alternative dispute resolution. So let's believe that you do not know what is ADR, and on that pretext, let me start with telling you that CPC, which is our procedural law, by inserting a provision, has laid down and has put a duty on the court. The court has to now the important aspect is it mandatory for the court to always refer the parties to ADR, or is it this is discretionary? Is the party bound, and are they obliged to go for ADR once it has been so recommended by the trial court, or is it something that is again dependent on whether the party are interested and both the parties are consenting for it or not? So remember these points when we read the provision, okay? And accordingly, we will understand that how the reading and how there are different, we have tried to cure the mischief, we have tried to see the purpose, and accordingly we say that it has to be read in a particular manner. Okay, so we are studying section 89 of CPC and we will just barely go through the provision. So this says where it appears to the court. Now, this basically is starting from here, that it appears to the court that there exist certain elements of settlement, right? And which may be acceptable to the parties. The court shall formulate the terms of settlement and give them to the parties for their observation. And after receiving the observation from the parties, the court may reformulate the terms of possible settlement and refer them to arbitration, conciliation, judicial settlement, or mediation. So if I have to simplify this to you, this section is basically saying that if the court, they're done with the pleading, when they realize that there exists a dispute and there are elements of settlement, they will formulate the terms of settlement. Now try to see the practicality of this. We have ADR mechanisms, we have Mediation Act, now we have Arbitration Act, wherein we already acknowledge the fact that the parties voluntarily on their own can opt for any of this. Now comes the position where the court is intending to send the parties for ADR. Now, why is ADR opted for? It is opted for bringing efficiency. It is opted for, going outside the court settlement, understanding that you do not have to waste your time in the procedural lacunas and rather immediately, effectively get the remedy from the court. Now, when this is the purpose, is the purpose getting fructified or is it getting nullified when you put these clauses? When under section 89, you tell the court that, listen, you will have to formulate the terms of settlement. Now, understand, formulating the terms of settlement, the court will have to hear the parties. The court may have to try to understand that what are the different arguments, what is the issue here, and then also whether these can be the terms of settlement or not. So the terms of settlement will come to the court when he has done this tedious exercise. And therefore, after this, now the section says that you have to give these terms of settlement to the parties. And after you give these terms of settlement to the parties, they will provide their observation to you. And from this observation, now you will observe whatever they have mentioned. You will reformulate the terms of a possible settlement and then refer the parties to arbitration, conciliation, whatsoever it may be. So the court had to acknowledge, the court had to find a resolution to see that whether this is the intention of the legislature when they introduced section 89. or was it not the intention? So if you see here, I have mentioned as well that, by the 1940 Arbitration Act, we had taken away this. Then later we again have inserted it and it has become effective from this. So for your preliminary examination, remember these dates. With the Arbitration Act 1940, this was removed. Then in 2002, we see that we have again brought this into effect. Okay. And now the judiciary, you will see the activism on the part of judiciary from Afcon case, from Salim Bar case, whether it is one or two, both those cases as well as Afcon case, you will see how the judiciary has tried to put interpretation to this provision in a way which is going to be helpful for the parties. Okay, so we will discuss that aspect now. Why are we talking about this? So we have one question paper. This is from Rajasthan mains only, wherein this question was asked. Now a 6-marker question, and try to see what have they asked. Explain the settlement of dispute outside the court as embodied under section 89 of CPC. Narrate the guidelines issued in leading judgments of the Honorable Supreme Court in this regard. So first, they want you to explain that how settlement of disputes can happen outside the court. And then you have to write your answer in context of the landmark judgments of the court. And that is why it becomes important for you to remember these cases as well. Okay. And these cases are providing you interpretation, providing you remedies as well. So I will tell you what all are the loopholes, and then we will read each case and we will try to understand what we are discussing here. Okay. So firstly, on the reading of the provision itself, we understood that these in chronology, whether we have to follow all of these steps or not, first thing that we have to understand. Okay. Then you will read this provision section 89 along with order 10. Order 10, rule 1A, 1B, and 1C. And let's try to see whether there is any conflict in the reading of these provision, or is this absolutely fine. So we see here that section 89 tells that once the parties have given their observation, the court may reformulate the terms and refer the parties for this. May. So the interpretation that has to be done is of this term may, and to be seen whether the court is duty bound to send the parties for ADR, or is it not duty bound to send the parties for ADR. Okay. And now this entire discussion is based on this section that we have here, this provision that we have here, order 10, rule 1A, which says direction of the court to opt for one of the mode of the ADR. After recording the admission and denials, the court shall direct the parties to the suit to opt for either mode of settlement outside the court. So here the term that has been used is shall, that the court shall direct the parties to opt for either of the methods and go for outside the settlement of the court. Now, if the parties agree, they will fix the date. If the parties do not agree, then they will not send the parties. If the parties agree and they go there in that forum and they do not get any outcome, they are not satisfied with the outcome, then they come back here again in once. So this is the chronology in which it is so mentioned here. You can take a screenshot, pause my video, and read these provisions. Do you really think there is any conflict that needs to be addressed? Here it says the court shall direct the parties. Under section 89, it says the court may reformulate the terms and refer the same to the parties. So therefore, this also has been answered by way of judiciary. Okay. And with regards to the discussion on mediation and judicial settlement. So when we further read, we understand that these are to be read interchangeably. So this is another legislative error. When we talk about mediation, we understand that mediation has to be done in a manner which is not getting fructified when we read section 89. So this also had to be seen, that whether there is any legislative error with regards to the terms that we have used here, judicial settlement in clause C and mediation in clause D. Okay, this is the third point that we will be discussing about. And we also have to see that is it binding for the parties. So the fourth point is it binding for the parties to go for ADR? What if only one of the parties is one of the parties is interested in ADR, what will happen in that situation? All these are questions that were put before the court, and the court has tried to answer it in a given manner. The court starts. I'm giving you a summary right now. I will run through the judgment also with you. So the court initially begins and says that first and foremost, we would like to start with strict interpretation or literal interpretation. And when we do the literal interpretation, we see that there is ambiguity. And therefore, to cure that ambiguity, now we are going to see the intention of the legislature. So when we talk about may, here this is mentioned with regards to formulation of terms of the settlement. The court has equated that the terms of settlement can be understood as the terms of referring the parties, terms of summary of disputes. So here the court does not have to get into the terms of settlement. Rather, at this stage, they only have to provide the summary of dispute to the parties and tell them that all these are the disputes. Which ADR mechanism are you interested in opting for? This is preferable for you, and then let the party decide for the same. All right. So this is the background of what were the issues here on reading in reading of section 89 and how it has been addressed by the court in different case laws. Now let's move to the case laws. Let's try to understand what all is relevant for you to mention in your answer. So I will start with the introduction. We have the purpose here, that is to promote outside the court settlement of section 89. Now I've written it in a manner of you to structure your answer. So you start with the, you do not have to write these headings. This I have put only for you to understand. But you start in a way that you understand, you give an idea that you understand what is the idea of section 89. And then when this is the idea, whether the purpose will be fulfilled or not. Okay. Then the court has to see that if these, if now. Also, another point is that the court has to see whether the subject matter, whether this case that I'm dealing with, whether this dispute is something which can be decided by ADR mechanism. So by our judgments, we've also understood, we got an idea as to what type of disputes can be referred for ADRs and what are the disputes which cannot be referred for ADR. For example, when we talk about something involving a right in rem, let's say a copyright, you cannot be referring that for ADR, right? Let's say when we talk about probate, that also cannot be referred. Something which involves public interest, something which involves the state state's involvement, right? Sovereign's involvement. So these are situations which have been now clarified from 2003 to 2005 to when we talk about 2010 Afghans case. All these are reiteration that has been made by the court and accordingly is to be seen by us now when we are deciding, by the judges also when they are deciding as to whether I should be referring this party for ADR or not. So the mechanism has been mentioned here. Then it is the choice of ADR is often left to the party. So very important factor is that we leave it to the parties that they decide as to which ADR mechanism that they want to opt for. But definitely the court's guidance will always be there. Okay. So all these are the initial introduction that you can mention in your answer. Then we come to the first case that must be mentioned in your answer. Okay. We have the Salem Advocate Bar Association 1 and 2. I've put the summary of both here. You have to know that later when this case has come, okay, this also has taken help of Salem Advocate Bar only. So therefore, you mandatorily have to remember this case. This case has done what? This has tried to give the implementation or has tried to give the interpretation that I was talking about. This is the case where it says that, okay, this may, which is mentioned in section 89, is not in conflict with order 10 and rather both are complementary to each other. So there are two things mentioned. One says may, the other says shall. There is no conflict. Basically here, what is required is that now this is the interpretation that they have given, right? What is required here is that the court has to formulate the summary of disputes. And then they have to refer this question, this choice has to be put to the parties as to whether you would want to opt for ADR or not. And it is not mandatory for them to refer them. but mandatory for them to get into the discussion of whether you want to opt for ADR or not. This is the window that is available to you. So all this clarity of may, shall, how it is to be read, how it is to be interpreted has been given here. Okay. Then the Supreme Court also formulated a committee to frame the model rules of mediation, and now we see that the Mediation Act has come. This also tells that how the ADR is a mandatory nature. Okay, so before referring to the to a particular matter for ADR, this is important for the court to understand that whether these cases are suitable cases or not, and whether these are of mandatory nature or not. Okay, then it also has clarified with regards to the distinction between judicial settlement and mediation. When they were doing the literal interpretation of the section, they understood that it was, it was not appropriate to do the same. It was not complementing the idea of the law, the idea of the provision, and therefore the court said that we have to switch between these two provisions. Where mediation is mentioned, it has to be interchanged with judicial settlement, and likewise for the other. Okay, and also the court has tried to make reasonable effort to find the elements of settlement that can be acceptable by the parties. So the court has tried to highlight here as to what all are the required or requisite points that you must inform the party of for them to be promoted to opt for the ADR mechanism. Okay, then moving ahead, we have the AFCON's case, again a case wherein we had to again discuss and understand that whether consent of the party is mandatory or not. Because here, in this case, one of the plaintiff was interested in opting for ADR, the defendant was reluctant, and despite of it, the trial court and the high court both referred the parties for ADR. Okay, so therefore here the Supreme Court clarified that this is not the idea. The trial court and the high court have mistaken, because here the other party, the defendants, were not okay with the fact of being sent for ADR, and ADR, whether decided by the parties mutually, whether let's say they agree for an arbitration clause, or if the court is sending, in both the situation, it is required that the consent of party is taken. Okay, so the court is to determine which cases are suitable for ADR. This is the example. Any case involving fraud, forgery, criminal offenses, public interest litigation, all these are unsuitable for ADR. So here, when you read the judgment, when you follow the judgment, you will see that they have mentioned all these points in the judgment itself. That this is not an exhaustive list, but we are providing a list for the parties to know that these are cases for which ADR will not be referred to. So these are unsuitable, and they also at the same time say that when there is a commercial dispute, something related to a property matter, you can definitely send it for ADR to be done here. Okay, they have also made distinction between different ADR processes. They have done a scrutiny of the nature of dispute before making reference. So this is important. We have to see, again, this is complementary to this point, that you have to see the nature of the dispute before making a reference for ADR. Okay, now from this, what you understand here so far is that first and foremost, ADR section 89 is a mandatory provision, but mandatory is not to push the parties to ADR beyond their consent, but rather to expose this idea to them to promote efficiency. Okay, the goal of section 89 is to reduce the burden of the court, and accordingly that gets promoted when we allow something of this sort. Okay, and that is how you can, this should be more than enough, but there's one more judgment that I've mentioned here, much, just after the AFCON case, we see much later than the Salim case, wherein again the court had very clearly spoken about that it is the duty of the court to apply their mind for them to assess whether this is a matter which can be settled by ADR mechanism or not. Okay, so this also becomes very, very relevant. This is also another case that you can definitely mention in your answer. All right, so these are judgments that have to be there when you are asked a question of this sort. Now I'll just show you the copy of the judgment, that is the AFCON's case, and there are certain relevant aspects related to it. Okay, so we will read in part as to what all is mentioned here. First is when we talk about section 89, they have done a discussion on this. They have said that if we start sticking to section 89's interpretation in a literal sense, it is going to be a trial judge's nightmare. It will be like putting the cart in front of the horse and asking the horse to run it. So this should not be so. Section 89 has an object which is laudable and sound, and accordingly it has to be promoted and it has to be seen. Then, as I told you, they have mentioned about both the Salem Bar Advocate Association case, wherein they have referred to that purposive construction was opted for, and accordingly, they have now tried to give answers. So, they tell that what is wrong with section 89 of the code. First, they talk about the two statements that have been used, the two terms that have been used have been wrongly mentioned. They talk about that how it has to be interpreted, and then ultimately they say that these two have to be switched with each other. Okay, so that has been done here. They have acknowledged that this is due to a clerical or a typographical error. Then the second anomaly exists with regards to the entire tedious task of the court, formulating the summary and accordingly, formulating the terms of settlement of dispute and giving it to the party. So the court has again here said that if we allow this in section 89, it will be violative of section 73 Arbitration and Conciliation Act. Because that under Arbitration and Conciliation Act, we say that this is the last stage where the terms have to be summarized, of settlement has to be summarized. So therefore, the court again here says that it is not to be done. And if we will allow this at this stage, there will be nothing left for the ADR or for the forum of ADR to actually think of, decide on. And therefore, this is not what we expect for the trial court to do at this stage itself. Okay, so this is the paragraph related to that. Then, as I told you, summary of dispute only has to be mentioned here and not the terms of settlement. Then they have spoken about that how section 89 is to be interpreted. So here, as I told you, plain meaning was not doing justice. They have explained a lot of paragraphs, different judgments. Maxwell has been quoted here, wherein they are talking about that how the literal interpretation is not doing justice to us. And they have mentioned about examples also, wherein we read may as shall, wherein we read plaintiff's witness as defendant's witness, and therefore ultimately the court has said that here we will apply the purposive rule of interpretation and we will see that how it is to be observed. Okay, so the court has to ensure that the terms of possible settlements are mentioned, but it does not have to put the entire go through the entire procedure before sending the party for ADR. Again, with regards to may and shall, I have already explained this to you. This has been discussed here again in the case. And therefore, in the summary, if you see, this is the ratio here. Whenever there is a pre-existing arbitration agreement between the parties, the consent of all the parties to the suit will be necessary. And accordingly, in this case also, where the plaintiff was not consenting for the same, the court has clarified that it will not be just for us to refer the parties for such, for the same subject matter where one of the party is not consenting for the dispute. Okay, so this in part will be helpful for you. All these summary that I have mentioned and I've shared with you, I believe this will give you a structure for you to write your answer as to what is the idea of section 89. You will also see that section 89 promotes and says that once you send the parties outside for the court for the ADR mechanism, they will then come back again. Let's say if they have concluded, they will come back here for the execution to be done. As a decree, it will be so executed. So we have tried to bring a balance, even though when the parties have instituted or have opted for the trial of a suit, we've tried to bring a balance with regards to how, because the judiciary will take a lot of time, because we have so many pending cases, accordingly, this will be a good mechanism to opt for. And also whatever lacuna is there, the judiciary has very specifically mentioned in the AFCON's case that till the time we do not make changes or amendment in the language of the provision, this interpretation has to be followed up till the language gets changed by the legislature. So I hope this was a very quick summary of what all is important for you to understand section 89, how you are expected to write your answer revolving around the essential points of each of these cases. If you want me to cover any of this case, let's say if you're preparing for Delhi Judiciary, you may or you would want to read each of these cases individually also, because it has been so asked in the exam. So we can do that exercise also, subject to what is your feedback and what else do you want me to cover in the upcoming classes. All right. Thank you so much, all of you. I hope this will benefit you. I hope you have understood the topic. If you have any doubts, you can let me know in the chat box. I'm right here, so you can let me know in the chat box now as well. Thank you. Thank you, all of you.